The key challenge in establishing malpractice in a birth or catastrophic brain injury case is, again, what a lot of people don't necessarily understand or realize, is that as a plaintiff representing patients in medical malpractice cases, you need an expert witness to establish this. A lot of expert witnesses, a lot of physicians will not testify against other doctors. So the pool of experts that I can draw from, or any plaintiff lawyer can draw from representing a patient, is a much smaller pool of people versus the defense, who can simply get anyone in the world to say whatever it is they want. And they oftentimes go and get one of the most highly qualified expert from around the world to come in and say the most outrageous things. But they're not just some guy off the street. These are highly qualified people who will say anything they want to get their doctor off. That's a big challenge. And the other big challenge is these cases are expensive. So whatever lawyer is going to pursue a medical malpractice case has to finance this case. A case like this through trial could cost easily couple hundred thousand, $250,000 or more dollars. It's a lot, and it's a big risk that the lawyer's taking. So I tell clients all the time, you better have a good case, you better have a good lawyer, you better have good experts, and you better have somebody with a lot of money to pursue it, and also the guts to go after the full way to trial. Otherwise, it's just a recipe for disaster. And so that's why the results we get here, 99.9% of all cases I file are successful. But if you look at the national statistics, 90+% of all malpractice cases are not successful. And that should tell you a lot. You don't have a good lawyer, you don't have a good case, they're not well funded, they don't have the guts to push the case. To establish causation in a medical malpractice case, you have to have a medical expert say it. So as I tell my clients all the time, it doesn't matter what I think, it doesn't matter what you think. I have to have an expert get up and connect the dots between the medical error, the negligence, and the bad result. It oftentimes seems very simple because the bad result happens close in time to the medical error. But when you start digging into the medicine, sometimes you think, yeah, it kind of looks that way on the surface, but sometimes it's not. On the other hand, the defense in every situation, I've handled thousands of malpractice cases. In 100% of every malpractice case I've handled, the defense has a really highly qualified expert to say that negligent act had nothing to do with that injury that happened right at the same time. It's still shocking to me, but they find them and they're good experts who will say the most outrageous things. So you've got to have an expert, and you've got to have a lawyer who understands the medicine and what's provable and what's not provable. Sometimes they're just not provable, but you have to understand the difference. The role of your medical expert is critical, but it's also critical for the lawyer to understand when the medical expert is being candid with you, or whether they're kind of leading you down the primrose path. And you really have to have a lawyer who understands that, because a lot of experts will tell you what you want to hear versus what you need to hear. And so it's very important that the lawyer understands when the medical expert is just kind of like telling you what you think you want to hear to establish a case, versus like, listen, this is the good parts, these are the bad parts, these are the problems. It's a case, but you got to look out for these things. Until you have an expert that will say that there was medical negligence and the issue of causation, you don't have anything. And so you have to have that as the nucleus of your case. An expert has to say, somebody committed malpractice and that malpractice caused the injury. That is the nucleus of a case. Now, once that happens, a lot of other experts will chime in on it, because the defense will hire up to a dozen experts to attack it. So every different specialty, they'll go hire somebody to attack it. So you've got to have your own experts. Even though you could prove your case with one or two experts, the defense is going to go hire 8 or 9, and you've got to have people to combat all these people to come up and rebut all the nonsense that the defense is going to bring up. It's interesting in medical malpractice cases that oftentimes the legal issues are not terribly complex. It's the medical issues that are really complex. The legal issues are basically, was somebody negligent, and did they cause an injury? And if so, what are the injuries and what's that worth? Those are, on that very basic level, pretty simple questions to answer. Now, it's more complicated than that. It's the medical issues that are really complicated. And oftentimes, sometimes you have to understand, when you're looking at a case that might go to trial in 2 years and deciding whether or not you want to invest and pursue this case, is, can I explain this to a jury that's going to understand it, or is it going to be too complicated medical-wise for them to really understand this? And that's really one of the things you have to look at, which gets back to what I tell clients all the time, which is a lot of times the medical error is just something based upon human frailty and human ignorance versus something that's complicated. If you start getting into complicated medical issues, those cases are much more difficult. If it's something that can be explained away by a doctor just being lazy and not caring, and we see a lot of that, those are cases juries really understand and probably they've experienced.